Welcome to our second Saudi Center for Commercial Arbitration, SCCA and ArbDB Chambers ADR webinar. I'm James McPherson, International ADR Specialist and SCCA Special Counsel. My learned friend Michael Cover, founder member of ArbDB Chambers, and I will be moderating our roundtables. And today we have three rapid rounds. The first is our Mediation Experts Roundtable, followed by a brief video clip, which we will show, and our roundtable with ADR practitioners from some of the major law firms working in the region today. We'll conclude with an executive summary and some additional insights of his own from Michael Patchett-Joyce, QC. So we're especially delighted that we have so many great colleagues with us today, including many seasoned practitioners, arbitrators, mediators, senior management professionals, and government representatives from across the MENA region, North and South America, Europe, Africa, and Asia. What brought us together today is our shared passion for ADR to resolve international commercial disputes and its application, obviously, in the kingdom, but also the wider region, and to perform at the top of our respective games and to encourage various reforms, refinements, and best practices. It's our goal today to share with one another all our individual and collective experiences to ensure we have the requisite information and up-to-date analysis of both domestic, international, commercial mediation, and arbitration. Few regions have made more advances in the field of ADR over the last decade as Saudi Arabia, and that record requires some unpacking. For detailed analysis, SCCA is happy to share a number of articles that have appeared over the last 6 years that highlight and provide real insight into what has transformed the kingdom into the ADR-friendly jurisdiction that it has become. So specifically, it will analyze the arbitration legislation, the ADR Center itself, the performance of the Saudi judiciary, the bar, the work of local and international practitioners, including men and women, old and young, legal and other professionals being retained as both arbitrators and mediators. And fundamental to the well-functioning of this ADR ecosystem in the kingdom, as everywhere, would be appropriate judicial support, successful enforcement at home and internationally, and ever-increasing caseloads in the kingdom for mediation and arbitration. Our speakers come from the kingdom and internationally, all leaders in their field. Session 1, the mediation in KSA, we will feature first from Saudi Arabia, a mediator and ADR practitioner, Rosanna Al-Tayyar, who is a skilled, neutral, and very popular trainer across the region. Then Musad Al-Harb, who's SCCA's business manager and partnerships development. And he's obviously done great things for SCCA in ADR, but I'd like to thank Musad's team, which includes Ms. Nof, that many of you have had the opportunity to connect with in preparation for today's webinar. Then SCCA's Chief Registrar and General Counsel, Chris Alberti. He's a colleague and with a long international career, including the GCC and Saudi Arabia, alhamdulillah. And then longtime Middle East hand, Dr. Mark Hoyle, who's an arbitrator mediator that many of us have had the privilege of working with over the last 15 to 20 years. So let's get started. I'll have some questions for each of the experts. I'll begin with mediation, and specifically with round 1. I'd like to explore some of the developments and focus on what makes mediation work in the kingdom and the region. So to begin, let's have some remarks from our colleague, Rosanna Al-Tayyar. Rosanna, welcome. There's new legislation regarding court costs in Saudi Arabia. And from your perspective as a mediator in Saudi, how do you see this impacting mediation moving forward?
This is a great question. Judicial costs and fees regulation in Saudi aims to reduce the number of malicious lawsuits the judicial system is currently suffering from, and encourage disputants to refer to amicable options such as mediation. This regulation has actually come as an opportunity for the parties to explore an informal, voluntary process where the parties have the power to shape the outcome based on their interests before escalating the dispute to a costly and time-consuming method. So I believe we will see an increase in requests to mediate once this regulation is in place.
Excellent. I think that it's important for those working in the region to know how each jurisdiction is functioning and what to expect, but also those from outside. Most of the people logging in today are from outside of the region, and they're interested in knowing. And so I think it's reassuring what you've been saying about your experiences, that although there have been challenges and issues along the way, that you've managed to address those in due course. I also want to echo what you said, because in the mediations I've done in the kingdom in the past, many litigants or disputants from the GCC have wanted to do their mediations or otherwise arbitration outside the kingdom. And the good news is that over the last several years, because of the things you've been talking about and because of things we're going to elaborate on today, much of that has changed. And so I don't have that experience anymore of people wanting to assemble in Germany or UK or whatever. They're very happy to hold their hearings and their sessions in the kingdom itself. I think, do you have any concluding remarks before we move on to our next speaker with regard to what business people need to consider when they're weighing their options about going to the kingdom to mediate?
Well, I would start by asking business leaders the following question: how do you deal with a business dispute once negotiations have reached a deadlock? Do you try again, resort to a third party to help with the negotiations, or proceed with litigation, or simply end the business relationship? I mean, in a Harvard Business Review article, Mark Gerson says, keep in mind that your ability to navigate conflict is one of the primary ways that you reveal your character as a leader. So you can navigate conflict by negotiation or by resorting to a neutral and impartial third party to help facilitate the negotiation to reach an acceptable agreement. This means that it is essential that executives and business leaders are fully aware of the options available to them to manage the dispute in a productive way. It is worth noting that Saudi Arabia has set up the infrastructure for an attractive trade and investment environment by establishing the Saudi Center for Commercial Arbitration, as well as ratifying the Singapore Convention on Mediation. So my recommendation would be to business leaders to ensure that the business interests are protected through a well-structured dispute resolution clause, emphasizing mediation, which involves no rigid rules or procedures, as a first step towards amicable resolution. Mediation gives executives the necessary control to craft an outcome which serves everyone's needs and interests, making them effective leaders and reliable models to the stakeholders of the organization.
That's well put. And I can tell you that mediating in the kingdom myself, if you closed your eyes, you wouldn't know where you were in the world. The caliber of the people is of an international standing. The council, whether they're local or international in the room, their experts, their management teams, they're really a very sophisticated group, as I'm sure everyone on this call is well aware. I believe Musad Al-Kharb is with us. I can't see his visage. Can he turn his camera on live? I think Musad Mojood? What we'll do as we're getting our brother into the mix, we'll press straight on to our next colleague, which is Chris Alberti. I think, I'm just seeing if, I don't think I see Musad there, fine. We'll get back to him in a moment. I know he's on site, he's just not on camera. So for Chris Alberti, I think it'd be helpful to hear from him as Chief Registrar and General Counsel of the Saudi Center, how basically the remote aspect of mediation conferences in the kingdom has impacted the use of mediation in the kingdom through the SCCA and others. So have you seen any impact in terms of the overall success rate, settlement rate between remote and in-person mediations? And has there been an impact on the holding of caucuses and other features of mediation itself?
Thank you, James, for allowing me to share my thoughts on this, and thank you also for this kind invitation to everyone. As to your question, while the jury is still out there at this point, we have at least observed slightly lower settlement rates regarding mediations that have been held remotely. There might be many reasons for that, and while the experience has been largely positive, holding mediation conferences remote creates obviously a totally different experience and negotiation environment. Of course, mediation doesn't have the so-called hot seat cross-examination, so that perceived impacts on providing evidence, if at all needed in mediation, is in my view neglectable. Also, not picking up body language, intonations, or any other nonverbal cues, again, will not break your case, as no one's really judging the veracity of what your witness says. What I found quite interestingly was a recent report on the psychological impact of remote hearings that was published by the Berkeley Research Group, which concluded that while the impact cannot be ignored, it is not significant enough to influence the proceedings. And that's for arbitrations, where it matters more than my view. That all said, as we all know, mediation is a people's process, and mental preparedness and, if you will, the level of commitment to engage plays a key role. Of course, staring at a screen, as we do today, for prolonged periods of time is considerably less engaging and demanding more skilled mediators to break the ice, particularly when you have no cookies and coffee on the table, and to essentially ensure that the attention span does not dip when it matters most. Now, it is not easy to walk away from a table. It is much easier to turn off a computer, if you will. That's also one of those key factors that we always have to be aware of. That is, in essence, I believe, where the real challenge lies is mediators that can even read and entertain a remote crowd. I think that is really important here. So for me, a key factor that drives the success rate is and remains the quality of the mediator, not so much whether it's remote or in person. James?
Well, I see a question here from Ahmed Sa. He said, what type of evidence is adaptable in mediation in Saudi Arabia? Are they the same as acceptable by the courts? I think, do you want to answer that?
I can simply jump in quickly for that one. What evidence in the classical sense, as you may see in adversarial processes, we don't see that often happening in mediation. It is really rather a process where you try to understand the business needs behind the scenes. Yes, here and there, mediation will also ask for a certain evidence. Show me the invoice that you're referring to, but it is rather a process where you, indeed try to facilitate the negotiation between parties as a mediator.
I think what's also interesting, and I agree with what you just outlined, Chris, I think is that mediation has the feeling of a series of sprints online as opposed to a marathon. That's been meaning that you sometimes have multiple sessions, whereas in a typical mediation, as all of you know, it tends to feel more like a marathon. You're all there first thing in the morning, and you might be there till quite late at night, or resume the next morning. But things tend to be resolved within a 24-hour period, by and large, unless, or maybe a supplemental session to address some of the evidentiary issues that the questioner alluded to. But in this form of mediation, I find it quite common to chop it up into bite-sized pieces, much as Chris said a moment ago, that as people stare at the screen, things wane. And so it's not a bad thing to let people have some time to gather themselves and collect their evidence. One last question, Chris. Because Saudi Center actually has been doing a pilot project with the Ministry of Justice, among others, and they're moving along quite nicely. I was curious to know what the fact that settlement agreements can actually be converted into enforceable bonds under the SCCA's Pilot 2 program. Do you think that has affected the way mediators themselves have handled the sessions?
Very good question. Allow me to give a little more background, and I'm sure my colleague Mossad will further explore that point as well. So we did indeed have mediation programs that allow parties to convert settlement agreements into a final and enforceable bond that can be directly enforced. It's almost, if you think about the Singapore Convention, at local institution level. Now, in contrast to what you may know as homologation processes in other jurisdictions, the SCCA has, as a specially accredited center by the Ministry of Justice, the power to take all necessary steps towards obtaining such bond for the parties within a few days. And under these special programs, we even did so at no additional cost. Now, like the Singapore Convention, perhaps also worth mentioning, the grounds for refusal are very limited, and the review usually relates to public policy, Shari'a compliance, and the usual ability to settle the dispute. Now, to the question itself, I think what this really goes to is, can a mediator be held liable? Because now you have an output that essentially is enforceable. We have seen that arbitrators now these days are not as safe anymore, if you will, in some jurisdictions, and can get sued. So how does it work for mediators? I think the best I can here say to calm down the situation is to say that we have Article 14 in our mediation rules that indeed excludes mediators from liability. In fact, no mediator shall be made a party of any judicial proceedings, and also no mediator shall be held liable to any party or participant in the mediation proceedings for any error, act, or omission. Now, of course, I cannot rule out that intent or even gross negligence may get you in trouble in some jurisdictions, but it's also true that parties can simply walk away from the negotiation table. So the risk here to being pulled into such a situation is rather slim. It may be comforting to know from mediators that the SCCA looks at the settlement agreements before it starts the conversion process. And it is mainly to secure compliance with, again, Shari'a, capacity to settle, and a few other factors. What is also perhaps noteworthy is that the Conciliation Center to the Ministry of Justice, with whom we cooperate, will ultimately approve the process, and then also will take a look at this. So in essence, many layers of protection until the conversion process is completed, though it's a very quick process. We're talking about days in the end, but there are some processes in place to ensure that you have an enforceable and not a non-enforceable bond. James?
Thank you. I think what's interesting too, I mean, obviously some of these things haven't been tested as yet, meaning I'm not aware, whereas I'm aware of, for example, the US and other jurisdictions where people have actually sought to bring mediation into the courts. And generally they've been handled properly by the judiciary, the rebuffed or the judges in places like California have not actually been willing to hear evidence or have evidence submitted to the court that had been previously submitted in the mediation context. But I think that the general consensus from the Saudi lawyers and international practitioners I've spoken to in the kingdom is that people are actually very much expecting that the judiciary will behave in a similar fashion and uphold the confidentiality and the inadmissibility features, as well as we hope the not having them prosecuted. We've had some in recent years in the wider region issues of arbitrators and others being prosecuted, but that has not been the case in the kingdom, alhamdulillah, and I don't think it will be repeated, inshallah, in some of these other jurisdictions. So I'd like to turn quickly to our brother, Dr. Mark Hoyle, and I see him there. Welcome, Mark. I'm particularly interested to carry on this theme about the differences, locally and internationally. And I wanted to know if there are any differences that you've found mediating commercial disputes in the GCC and the UK, and if there are any concerns you've heard from clients who are considering mediating in the kingdom that maybe you haven't heard in other jurisdictions.
Yes, it's an interesting one because I have had one about a month ago, and one of the parties said, well, we can't go to the Middle East because they just don't do the thing proper. And it's one of those ridiculous things where you have to turn around and say, look, you've got to sort it out because you have to have it to sort it out, otherwise it's not going to work. But that is the same, I'm afraid, in many places. And I said, for example, in one of the I can't say at the moment who the party was, obviously, but one of the French parties would say, look, we can't do it. We can't do it because we don't actually want to have people in the Middle East doing things in that case. And I said, look, you just take it. It's the ordinary time. So I was persuaded it. I was persuading the guy, which is, I was the first guy there doing that, that it's perfectly okay. And after about 2 days, he said, okay, both of the people like it, well, let's do it. And I thought that was right and proper, but it's difficult. It really is difficult to persuade people from England, for example, or France or something like that, to do something overseas, and it's difficult, and it's rather outrageous in some ways. So, but I've done it, and I'm sure many other people have done it, and it ought to continue.
I think in terms of what people's expectations are of the region, I think it's always important to remind those outside that there are no restraints in terms of travel, in terms of representation, in terms of language, in terms of facilities, in terms of even the supports of the courts in the kingdom. And I think that this may not have been the case in decades past, but that is certainly the case at present. And it's a very impressive situation because you've got people from literally across the world, men, women, young and old, lawyers and non-lawyer, neutrals, experts, and others coming to the kingdom to do this. So I think people need to realize how flexible and open the jurisdiction really is, and accessible. Obviously, at present, COVID is making all of this seem a bit of a challenge, which it is, but I think the virtual certainly closes that gap. Just one second question for you, Mark. Thinking about what do we need as practitioners and as the SCCA and ArbDB chambers and others, those who are commenting, reviewing, and collecting information, what sort of data or information do you think would be helpful to collect on our part to help strengthen the case for mediation in Saudi and in the GCC generally?
Yes, it's a difficult one, but I can give a little bit of the Algerian one, which I was going to talk about, and I've decided actually I'm not going to say anything about. But the Algerian parties found it very difficult to make the case for either side, and then the aunt actually had to get into it at that stage, and then everybody else will tick in. Now that's perfectly okay if the aunt and the other family will accept it, but if they don't accept it, it's going to just cancel it out. But it's difficult, and the Algerian case, which was the first time that I had in that particular case, was very tough, really tough, and there was a third party, and it's obviously making either broken down or building up, but it's very difficult. So, but you can do it. You can do it if you can persuade people to do it. It's rather like all of the cases. If you can persuade people, you can get it.
I think it's interesting too to consider when Chris said that perhaps some of the mediations haven't been resolving as quickly with the virtual model. I think this affects the stats in a way that should also include, for example, the fact that it is easier, less expensive, and easier to ramp them up. So I suspect I've seen that there's been an increase in mediation. And I think a lot of people are moving more quickly to it because it is easier in the virtual environment. There are no planes to board, no visas to be had, and whatever for different participants. So I think that the ease of kicking it off is probably impacting statistics as well. But look, we do have our brother Musad now with us, so I will get straight into Musad. Hello. I wanted to ask Musad about this SCCA MOJ pilot project, which has been going on for some time, this cooperative agreement that we have. How would you generally describe the first steps of this process, and can you shed some light on this special project? Because it is something quite innovative for the kingdom and the region to have this cooperation between an ADR center and the Ministry of Justice.
Well, thank you. First of all, thank you so much, James, for the kind introduction, and also would like to welcome our colleagues, the distinguished speakers here. And also, as a SCCA member, I would like to thank our partners, the ArbDB, and for their interest in partnering with us in such an event. I probably will not maybe add as much as our distinguished colleagues mentioned, but I might also just shed light about let's say the process of the collaboration between the SCCA and the judicial sector in the kingdom, represented by, of course, the Minister of Justice. Well, the beginnings actually started I mean, somehow a long time ago, since like 2017, even before what is usually called the conciliation organization activation, which is in Arabic تفعيل منظومة المصالحة, where the communication and discussions were conducted between SCCA and the Commercial Courts Development Commission on discussing how can we refer commercial cases from courts to SCCA to be resolved by mediation. It was a new area, new process for both of us as the judicial sector, how to transfer these kinds of cases where the parties already they have the opponents between each other, and also with no agreement to choose mediation, and also for us to how can we manage the relationship with such judicial sector. Well, and I'll not say a couple, but many actually meetings, discussions been made on discussing the rules, procedural matters, the technical and logistical trainings and etc. to succeed in this initiative. And
sorry.
Yes, please go ahead.
No, tafadhal.
Okay. So and that was being actually officially translated in on October 2018, where the official MOU has been signed between the SCCA and the Minister of Justice to enable mediation in commercial courts, and then I would say the first pilot project, SCCA MOJ pilot project, launched, where it was targeted several points. For example, speaking of the geographical side, it aims to target the Riyadh Commercial Court as a very limited source of cases, and also the amount it aims to target the small, let's say, amount of disputes, the 300,000 Saudi Riyal disputes and lower, and also in terms of the representation, it aims to receive cases directly from claimant and respondents without representatives or lawyers, and also to make sure that these kinds of cases were submitted as a first submission in court, just to make sure that these cases weren't reviewed before in court. That project was actually executed physically, where me, myself, and also our colleagues, case counsels, were attending in hearings and along with the judges and the parties weekly to trying to convince parties after the judge, once he reviewed the first, let's say, submissions from parties, to encouraging them to choose mediation through an independent institutions such as SCCA, where he can refer to us, so parties can ask questions and get the answers before they sign on the mediation agreement on spot to refer their cases. Where we managed, thankfully, to actually transfer around more than actually 19 cases were transferred at spot from the court SCCA to be resolved by mediation. That shows, we believe, as a first steps on the transformation of the dispute resolution for Saudi parties from litigation to mediation.
Well said. And I think it's important to note that historically, all the jurisdictions around the world, it was court-connected caseloads that got things sort of going. I mean, in some places like Canada and the United States, it was insurance companies who used it for some of their mass claims and the rest of it quite effectively. But ultimately, around the world, it has been court-connected programs that have raised that awareness, developed the credibility among the user community, and there's been considerable uptake. And what you alluded to, Masad, a moment ago, it's really important, the work of the centers in converting, inviting, educating, converting people's interest, or reaching out to people to convince them to consider participating in mediation. And during the networking session at the conclusion of today, where you'll all be invited to join, you can actually ask Ms. Rosanna, because she's among many of the Saudi mediators who have done these cases in connection with this program with the courts. And I'm sure, I know from a past experience, she has some very good and useful insights on that. Just to conclude very briefly, Masad, could you speak to perhaps what you see yourself and the SCCA in terms of the appetite and the demand for mediation? How do you see the market for those who are interested in what the activity level looks like, at least from your perspective?
Well, I can assure you, James, that the appetite is high. As far as we notice and we see as an institution, as an independent institution from the judicial sector and the parties, there are actually there is a huge interest in mediation. We believe the challenge was only in enabling this kind of interest to be executed, and also raising the awareness of the concept of mediation in parties, especially, I mean, speaking locally in Saudi Arabia, we believe still the whether legal and business sectors, they need to be more educated, more trained in mediation, whether as a parties or representatives, or even as a mediators. The second pilot, for example, which took place after the pandemic, which transferred all the cases to be resolved virtually, in a huge transformation of resolving all the dispute procedures by online, with, of course, the help of our colleagues, the mediators, especially Ms. Rosanna, who worked with us in this pilot as well. That showed the real interest in parties in resolving their dispute, who they actually were demanding to succeed in this process, even though there were a huge and big technical difficulties and issues. Some of it prevents parties to continue in the mediation process, but still parties, they are keen to go again and start the process again, just to resolve it by mediation. And that, by the way, that was even before the judicial fees law that has been issued. So yes, so the appetite is much higher.
Thank you, Ustad Musad. I think even Musad was among the many people at the center who on occasion have heard the raised voices of some of the parties in the mediations I've done at the center. So I think it's important to stress that it really is not only culturally appropriate, but but highly effective. Even those ones where people were audibly engaged and emotional, they did resolve. These cases do tend, as all of you know, to lead to a resolution. So it is a highly effective process in the kingdom to date. We're just, before we get on to the practitioners roundtable, where we have our colleagues in from in and outside of the kingdom, we're just going to show a very quick 2-minute video clip. And I will turn this control over to our people in Riyadh so they can just run this very brief clip.
Where can you find a more flexible and effective solution for resolving commercial disputes? Where does justice move at a faster pace, saving you a significant amount of time, and the process and enforcement are simplified? At the Saudi Center for Commercial Arbitration. Saudi Arabia's National and International Center of Excellence for Institutional Commercial Arbitration makes it easier to do business, support investment, enhance contract effectiveness, and access to justice. It is competitive with preeminent arbitral institutions around the world, not only in expertise and services, but also in its fees. In fact, SCCA has reduced its case registration fees by 50%. That will be credited towards the total amount in administrative fees. Furthermore, SCCA has adjusted its fees to correspond to the value of the dispute. It starts at 2,000 riyals and is capped at 300,000 riyals for any arbitration case, even if the amount in dispute is 30 billion riyals. As for arbitrator fees, the new fee schedule reduces them up to 30%. The parties can now choose to compensate arbitrators for their time incurred on either an hourly basis or based on the amount in dispute, also known as the ad valorem method. SCCA helps you choose the ideal type of arbitration for your dispute by understanding how much the arbitration proceeding will cost you, even before you file your case with SCCA. When you open SCCA's interactive calculator on our website, you can see the cost by entering the amount in dispute in either riyals or dollars. The calculator provides you with the total cost of arbitration based on your selection of the type of arbitration: ordinary, expedited, or online, or ODR arbitration, and the number of arbitrators, 1 or 3, you decide. For example, if the dispute is worth 1 billion riyals, the calculator gives you estimated total fees that are 27% lower than in the previous fee schedule. Helpful news. What about smaller disputes? Is your dispute worth 200,000 to 4 million riyals? The calculator will provide you the cost details for expedited arbitration, which will cost you about 20% less than ordinary arbitration with 1 arbitrator, and about 66% less than an ordinary arbitration with 3 arbitrators. If the value of the dispute does not exceed 200,000 riyals, the calculator will show you 2 options: ODR and expedited arbitration, with details for each. It will show you that ODR is the most cost-effective option here, as it saves you 56% compared to expedited arbitration and 65% compared to ordinary arbitration with 1 arbitrator. Not only that, SCCA now also allows for flexible solutions such as the possibility to advance arbitrator deposits in installments as outlined in a newly amended Appendix 1 to the SCCA arbitration rules, all to ensure maximum party autonomy and choice. Try our fee calculator and see the exact fees for your case. Saudi Center for Commercial Arbitration, providing access to justice.
Thank you very much, Ria. That was a very engaging video. I think it's really important, this sort of video, and for three reasons. One, if you look at arbitration and ADR centers around the world, a lot of their videos are targeted strictly to their local market. I get the feeling from this video, obviously, that we're really interested in the globe, but it provides a tool. And I think people want to compare what the rates are going to be like here and there. But at the end of the day, a lot of practitioners insist that parties adopt stepped clauses, meaning negotiation, mediation, and then if required, arbitration in lieu of final litigation. And so I think we heard some good things about mediation from our panel now, and we're going to shift gears. I'm going to turn this over to our colleague in London. I'd like to introduce our co-host and moderator, Michael Cover. He's founder, member of ArbDB chambers in London and worldwide. And Michael's going to introduce and facilitate the second round, which is with our expert panel of practitioners. Michael.
Thank you, James. The theme here is how is arbitration working in the kingdom and why? So our first panelist is Zohad Kashem, and he's the managing partner of Kashem and Associates, and he's got both qualifications, legal qualifications in the US and in the kingdom. He's also got a Bachelor of Engineering, so he's dual qualified. Zohad, I wonder if you could just maybe set the scene for us and just tell us a little bit about how you see arbitration working in the kingdom and why. And I was going to ask you in particular about the role that the Saudi courts have in Saudi arbitration proceedings. So Zohad, over to you.
Thank you very much, Michael, and thank you very much to the SCCA for hosting us for this great event. I'm going to be sharing a couple of slides here to kind of position us within the discussion. So if I may go ahead and do that, see if this works. Okay. I think this should be working now. Do you see my screen? Okay, so essentially the question was, what do Saudi Arabian courts, what role do they play in connection with an arbitration? And in order for us to answer that question, we figured that we would outline it in 3 phases: the role of the courts before the arbitration actually commences, the role of the courts while the arbitration is ongoing, and the role of courts afterwards. So let's go ahead and dive into it. In terms of the role of the courts before arbitration, James mentioned this just a moment ago, is that various contracts call for an escalation mechanism between the parties, that before they reach arbitration or litigation, they need to go through some kind of mediation process, escalation process to their senior personnel. We've had very good experience in having courts enforce those provisions before they would allow one party to call for an arbitration to commence. So the court's role in connection with arbitration before arbitration commences is to enforce the agreement between the parties in relation to how arbitration can actually be invoked. The other role that local Saudi courts would play in the context of arbitration is that if there is a dispute over a sole arbitrator in a sole arbitrator arbitration, or for the president of a panel to be appointed, then you would go to the courts and the courts would appoint one for you, assuming, of course, that you've not utilized a institutional set of rules that govern how the tribunal would be constituted. So that would be another role that courts would play. Okay, so now that, let's say you've constituted your panel, the arbitration panel, and you know they've started their work, and there was no escalation clause, or an escalation clause was there and was enforced. While the arbitration is ongoing, the court still plays a very important role. Think about the court as kind of the ultimate power, the place where the tribunal will get their power from in a number of different issues. So the first thing is that the court can remove an arbitrator in certain cases, like bribery and conflict of interest, if it is proven to the court. So that is something that the courts could play a role in. Usually courts are not as accommodating with those requests, and actually set a quite a high bar for the litigants to prove before they would dismiss an arbitrator, at least in my experience. Another thing that the courts would be involved with is if the tribunal needed a temporary preservation or an injunction to be issued, for example, in relation to a construction site, to ensure that a construction does not continue or an asset is not sold. the tribunal would seek that from the court. So that is another form of support that the court would provide the tribunal. And the third aspect of where a court would play a role during arbitration is just general assistance in relation to calling for witnesses, requesting certain documents, issues relating to the discovery type requests, and so on, that the tribunal may not be able to provide. So far we've been talking about the role of courts. I've presented the role of courts before the arbitration commences and about the escalation clause and disputes over the tribunal. And then we moved on to the role of courts during arbitration and the ability to move and remove and kind of support the tribunal. What happens after the arbitration ends? Well, the role of the court there is quite simple: either validate or invalidate the award. And I saw, as we were listening to the fantastic discussion on mediation a moment ago, is whether an arbitration award is final and binding. It is final and binding. That is the case under Saudi law. However, under very limited circumstances, Article 50 of the Saudi Arabian arbitration law sets out very limited circumstances by which you can convince a court to invalidate the award. And essentially, they go into kind of two themes. One is whether the award does not meet Shari'a principles or did not afford the other party the ability to defend itself, or what everybody knows here, that has acted as an arbitrator, jurisdiction. Essentially, that is the one point that all of us as potential arbitrators and as actual arbitrators need to know, that you need to act within the confines of the framework that you've been given, within the contract and the agreement between the parties. And whatever you think is equitable, whatever you think is fair, you cannot go out of that because you risk a court invalidating your award. And of course, you go to the court to validate your award by having the court add the enforcement language, turning it into an enforceable instrument that then you can take and enforce in an enforcement court. So that's the role of a court before, during, and after. Michael, back to you.
So thank you. I thought that was absolutely crystal clear, and it really gave us great food for thought, particularly interesting on court assistance on the formation of the tribunal. I just have one other question just before we move on to Stuart, and that is, to what extent is the government or state-owned enterprises in the kingdom being able to use and is actually using arbitration? Sorry, I tell you what, you've just taken me back to recent legal developments. Why don't you just go ahead with that one briefly?
Sure. Yeah, I'll do a very quick overview. And
sorry to take you a bit off piece there.
No worries. A number of people have already raised a few of those points. So in terms of recent legal developments, and these are quite important because quite a lot of them fall into the general theme of regulatory reform in Saudi Arabia, and here, of course, specifically judicial reform within the context of Vision 2030. So what has occurred over the past couple of years, and this is a quick review over that. The first is what Rosanna mentioned earlier, Judicial Costs Law. This is very important because it now introduces a cost to engage in commercial litigation. Not every court requires a fee, but certainly commercial litigation that falls under certain requirements will require the applicant to pay 5% of the claimed amount up to an amount of 1 million Saudi riyals. So that makes litigation now perhaps not as attractive as it once was as a free option to litigate, and hopefully will decrease caseload to courts and enhance the ability of courts and judges to focus on the cases that they have. Another important addition to the Judicial Costs Law, which by the way is not yet law, has been announced. It will be distributed in the official gazette, and then 6 months later it will come into effect. So it's still a ways away. But in relation to arbitration specifically, arbitral awards, as I just mentioned, an applicant can apply to invalidate the award. If that applicant loses that request, that party ends up paying 1% of the value of the award, or up to 1 million riyals. This decreases the ability of, or decreases the likelihood of parties to move to invalidate awards based on a whim or just a procedural aspect, just to prolong the process, where now they know they're going to end up paying a bit more if they determine that their case is not as strong as it could be. Another piece of legislation that was issued last year, the Commercial Court Law. This was a very important development. It allows now the parties to commercial disputes to essentially agree bespoke litigation, how evidence will be presented, how case briefs are going to be presented, the timeline, how witnesses will be called, and so on. So this creates a kind of almost a pari passu measure as compared to arbitration that allows litigants to or parties to litigation to agree the way that they conduct themselves, and also allows the publication of or the rapid publication of opinions from courts, thus giving litigants and parties a bit more predictability in relation to the outcome of their cases, because they can see where courts are at. And just a few weeks ago, the Saudi Arabian arbitration law itself was amended and to remove the need to have a contract with the arbitrators. This is a strong indication of support to institutional arbitration, because, as you know, for institutional arbitration, you can essentially have your contract with the institution as opposed to with the parties, and this moves in that direction. So, Michael, that was the second part, and I'm happy now to answer your third question, if you'd like me to.
Well, just very briefly, this was the use that in the kingdom that governments and state-owned enterprises are able to use arbitration. Just maybe a minute or so would then
Sure.
we keep to time. Thank you.
Absolutely. Thank you very much, Michael. Okay, so again, keeping with Vision 2030 themes, keeping with judicial reform. Everybody knows that the Saudi Arabian arbitration law prevents government entities from using arbitration to settle their disputes unless a specific law is issued in relation to that, allowing them to do so. Two laws have been issued that allow this now. The first is the government procurement law. When the government procurement law was issued, it allows the Minister of Finance to have any government entity resort to arbitration. This is fantastic in relation to a number of the projects that are happening around Saudi Arabia, in that now international and local investors and contractors can opt to have arbitration should the Minister of Finance agree in relation to certain types of projects. So this is great news, certainly, for government procurement. The second law that was issued, when the Council of Ministers passed this law, it stated that the National Center for Privatization will issue certain rules that would then allow any government entity that engages in a privatization initiative and a contract to utilize arbitration, and in fact, even foreign law. So that is also a fantastic news for privatization in the kingdom, and gives the NCP more of more tools in their arsenal to be able to meet the requirement that perhaps international investors and local investors may have. And to support the SCCA, a high order was issued that basically instructed government-owned enterprises and entities to utilize the SCCA when dealing with foreign enterprises, unless, of course, their own specific bylaws or rules called otherwise. So that's essentially a quick summary of the various developments that have happened. As you can see, the overall theme across all of them is that there is certainly more of a move to support arbitration and allow government entities to engage in arbitration. So with that, I'll go back to you, Michael.
Okay, so thank you. My thanks. Thank you, and thank you on behalf of all the attendees. I'd like to now turn it over to Stuart Patterson, who's the Managing Partner Middle East and Head of the Middle East Dispute Resolution Practice of Herbert Smith Freehills. Welcome, Stuart. I was going to ask you, just really following on from what Zahad was saying about what role Shari'a plays in arbitration in the kingdom. Stuart.
Thank you very much, Michael, and thank you to James and everyone for hosting me on this event today. I'm conscious of time, so I'll try to keep my comments relatively brief if I can do. I think the issue of Shari'a arose to me as an important point to mention when sort of sitting back and thinking about the topic of this event today, which is how well arbitration is doing in the kingdom and why. And for me, that is very much around a number of key factors or considerations that the country has to take into account of in order to support the growth of arbitration. One of those is essentially government commitment to delivering it. And we've seen that through some excellent legislation in terms of the arbitration law, the enforcement law, the law creating the SCCA, and of course then the regulations that it provides. So a number of very positive legislative developments have really transformed the arbitration landscape over the last decade. And of course, together with that, training and awareness among the judiciary to support that transformation of the legislation. And another key consideration is certainty. Investors looking to develop projects or make investments into the kingdom are looking for certainty in relation to how their investments will be looked after once they've made them. And it's those investments that, of course, in due turn generate disputes and arbitration. So without the investment, there won't be the arbitration. And that certainty consideration is the one that gives rise to a question mark about the role of Shari'a. And the third, but I'll just mention it very briefly, is the competitive position. Of course, there are a number of other GCC states that have launched with quite a good degree of success arbitration centres that are looking to win arbitration business, not just relating to their own jurisdiction, but more broadly around the region. So DIFC, ADGM, Qatar, and of course the BCDR, which we're very close to James's heart, have won a great deal of arbitration around the region. And for work that covers Saudi Arabia over the last so many years. And I think Saudi is slightly behind in terms of winning that work. And of course, it's making great strides now in catching up, but it is slightly behind competitively, I would say, in terms of the timing of the developments that it's made. So going back to the point about certainty and Shari'a, the laws that have come into place in the last few years are all very much modern laws. So the arbitration law is closely is very similar to the inter-trial model law. There are a few small differences, but there are, of course, a number of references to it being subject to the provisions of Shari'a. And as a foreign investor not familiar with the role of Shari'a in the Saudi legal system, that just creates an element of uncertainty and doubt as to how a matter might ultimately be dealt with when it reaches a tribunal and then subsequently in relation to enforcement. And I think that's just a matter that needs to be kept in mind. I'm not saying it needs to change, but it's a matter that affects confidence to an extent among foreign investors. I would say, though, that there have been a number of developments in that area that have been very positive. So, for example, in relation to one obvious area, there's a lot more practitioner awareness of the areas of Shari'a that are likely to be of concern, both in terms of substantive law issues, but also procedural issues. So, of course, on the substantive law areas, practitioners generally know that interest isn't going to be enforceable if it's contained in an award and you bring that for enforcement in Saudi Arabia, or something that relates to other areas that are contrary to the principles of Shari'a, such as gambling contracts. But there are, of course, areas around the edges. So, for example, derivatives contracts or life insurance, areas like that where there is still uncertainty. And I think there is room for improvement in terms of those sorts of areas, more clarity around what is and isn't acceptable. But going back to my point about the positive trend, and I know Henry will talk about a lot of cases in a moment, but we've recently been involved in a matter which involved a Saudi party and a very eminent Saudi arbitrator as a member of a panel of 3, and another very prominent regional arbitrator. In which an award was given against the Saudi party, which recognised our client's claim for late payment charges, And it seems to me that you could essentially have swapped the words late payment for interest. It was essentially the same thing. But the tribunal found that the payment in question was essentially compensatory in nature, and therefore upheld it at a level that was a good figure from my client's perspective. It wasn't a derisory or nominal sum. It, however, distinguished the right to that compensatory sum, which was paid in relation to the historic period up until the date of the award, versus making an award in relation to any period until final payment, any future period, because that future period involved uncertainty and therefore would be contrary to Shari'a. So that seems to me to be a very good example of a more sort of positive, purposive approach to international business contracts, and how they can be applied in a way that that makes sense of those contracts in the way that they were intended. I think that's a very positive development. I think also another development that's positive, well, I say development, a feature of the arbitration law, is that there is an ability to separate out, when looking at enforcement, any elements of an award that are contrary to Shari'a or public policy, but leave the rest intact, rather than for the entirety of an award, for example, to be annulled where there is a part of it that is inappropriate for enforcement. So those are my sort of headline points on Shari'a and why it's relevant. And I think it's just a question of how we can improve in certainty and predictability to achieve better investor confidence. But it's certainly happening already, in my view. And I think the other point made about the big projects that are being launched and undertaken in Saudi is another good example of that, because increasingly those projects are seeing Saudi arbitration clauses being used, which is a clear sign that foreign parties are very happy to arbitrate in Saudi Arabia.
Stuart, thank you. Would you mind if I moved on to Henry, because you started to take us to the theme of enforcement, and one of the things that has come up on Q&A is how you enforce arbitral awards in the kingdom. So if I may pass over to Henry, and thanks, Stuart, on behalf of everybody. Henry leads the practice of DLA Piper in the Middle East, and he also sits as an arbitrator. So, Henry, I think I was going to ask you about enforcement generally, because that's come up on the Q&A, but I think there's some recent cases that you were going to mention. So, Henry, over to you.
Thanks very much, Michael. Look, I'll jump straight in, but just to take the initial point, which is how do you enforce? And it's important that people know that this is all now online and ex parte in the first instance. So for people who think that Saudi litigation is in some way backward, it isn't. It's an online application. The initial enforcement application is ex parte, so the enforcement judge will make an initial decision ex parte, so without involving the award debtor at all. And it's only if he decides that it's an enforceable award that you then get the award debtor notified, and then they come and try to challenge it. But yeah, just to share 4 examples of enforcement cases, just so people can see, I think, from what's just been said, that the building blocks are in place for a good enforcement and arbitration regime in Saudi. It's important now that we see track record, and that's been the case throughout the Middle East. You need to show the track record to get more confidence. So just quickly talking about 4 awards. First award is one I've written about and spoken about previously, which is the Intracom Award. That was the first award, so far as I'm aware, which was successfully enforced under the new enforcement law, an ICC London award, $20 million. The key challenge to enforcing that award was demonstrating that London, the English courts, as the courts of the seat of the arbitration, would reciprocally enforce Saudi awards. And that was the stumbling block there, which we got over. So it's important that you deal with reciprocity when you're making your initial application. It may be that you can deal with it simply by demonstrating that the courts of the seat are in a country which is signatory to the Newell Convention. It may be that the Saudi judge needs more than that, but that's the starting point. The second case was an ICC Paris award. It was a construction case. A German company got an award against a Saudi party. I guess the key question that came up on that one, again, it was successfully enforced, so another good news story. The award debtor came forward and said, I wasn't notified of the arbitration, so you need to set aside your enforcement decision. The enforcement judge reproduced evidence showing that it had been notified and just simply chose not to take part. So the enforcement judge himself dismissed the application. He went on appeal, and the appeal court not only dismissed the application, it also said very helpfully and positively, I think, that the enforcement court doesn't have jurisdiction to hear challenges to the award. It's a procedural court, and so it doesn't have jurisdiction to even hear those arguments, which I thought was a very positive development. Quickly, the third case was a Cairo award. I wasn't involved in the case, but I've seen the decision. And in short, it was a Saudi government entity which took part in the Cairo arbitration, but on enforcement argued that since it was a government body and hadn't obtained the approval that Zayad was talking about, the arbitration agreement was void. And the court in that case decided that since the award debtor had participated in the arbitration without challenging jurisdiction, it couldn't now go back on that affirmative submission to the jurisdiction of the tribunal. And then the final one, if I've still got time.
Carry on, just briefly.
Yeah, the final one is currently unsuccessful, but for understandable reasons. And this is why it's very important that you educate the tribunal during the arbitration about what needs to go in the award. And in short, the award stated that so-and-so, the claimant, is entitled to X amount of money. That's all it said. And the enforcement judge said that was insufficiently clear for him to order the respondent to pay the claimant money. And so that's unfortunately been unsuccessful thus far, but perhaps for understandable reasons.
Thank you, Henry. We've got about a minute and a half left. I was just going to ask you about your view of arbitrating in Saudi. I think I'm going to know what you're going to say in using ad hoc or using the institutional rules of the SCCA. Right.
First thing I should say is that I agree with Stuart. I'm seeing a lot of SCCA arbitration clauses now, and the communication with clients has changed significantly in that clients are much more happy to choose the SCCA, whether it be from a positive perspective of what arbitration in Saudi is like, or a kind of let's bite the bullet now rather than have the arbitration elsewhere and then enforce it in Saudi. Whichever way it is, it's increasing. But in short, my own current experiences don't choose ad hoc arbitration in Saudi because, like many jurisdictions around the world, it means that there's room for messing about. Normally, through refusing to appoint an arbitrator and challenging an arbitrator when appointed, and that can push out the appointment process for the tribunal by many months, in my personal experience, unfortunately.
Okay, well, Henry, I think we've brought ourselves back onto time. So thank you to all three of you for that, and also for some really exciting and positive stuff that's going on to the kingdom. So James, may I hand back to you and to take us on to the next stage. Thank you. I think you're muted, James.
Apologies. Thank you, Michael. And very good news indeed. I think, as Stuart was mentioning, part of the task is to convert a lot of the pre-existing ad hoc cases to institutional, which, by the way, has been going on since pretty much the day the center opened. So a lot of people have opted for that, quite rightly. And also judicial dialogue to ensure that what Stuart mentioned and what Henry mentioned and Ziad mentioned continues, i.e. that the judiciary is engaged. And I can tell you that Dr. Hamid Mirah, the CEO of the center, and has led, and we've all engaged with dialogue with the judiciary for the last decade, and it's paying off. And the judges themselves have been very consistent and clear that they're there to support the party's autonomy and intent and interest. So they're not there to be obstacles, but to facilitate things. And one of the articles from the GAR speaks to the judicial record of enforcing foreign awards and foreign judgments, which again, we can share with you. But I'm delighted now to move on to our final session before the networking event. And that is to a dear friend and colleague, arbitrator, mediator, and barrister, Michael Paget-Joyce QC, who has the honor of summarizing and perhaps adding some of his own insights on practice in the kingdom. Michael.
James, thank you very much indeed. Well, I must say that as I sat here, I felt increasingly like the Shadow Chancellor of the Exchequer being expected to respond to the budget, where much detailed and careful preparation goes into the presentation, whether of the budget or in this case, the webinar, and yet an instantaneous response is then required. So I shall do my best. And in these closing remarks, I really want to do three things. The first is to say a word on behalf of the audience. It is indeed a pleasure and a privilege to express our thanks. And of course, up till now, I've been a part of and a member of the audience too, to the panelists and to the moderators of both panels for presentations of excellent quality and content. I've enjoyed listening to what you've said and also the clarity with which you've said it. I've certainly learned a lot, as I'm sure everyone in the audience has. So my first task is simply to say thank you. The second thing that I want to look at, I'll look at in a little bit more detail, and that is to try to put what's been said in a contemporary context, and to do that largely by drawing out the strands of what has already been said. And it's not only the direction of travel of ADR in the kingdom that is impressive. That, to continue the analogy, has been well signposted. It is, in addition to the direction, the speed with which the ground is being covered, that I would say is uniquely impressive. And amongst many of the speakers, Stuart, of course, touched on this, saying that from a relatively slow start compared with other jurisdictions in the region, Saudi Arabia, to mix my metaphors at this juncture, is very much coming up on the rails. And of course, in this context, most ADR centres take literally years to find their feet, whereas the SCCA has found a firm footing immediately. I don't want to be held to precise numbers. Chris Alberti can provide those, but I do know that filed requests for arbitration are comfortably, very comfortably, into three figures, with already tens of completed arbitrations. The mediation program has met with continuing success too, as both Rosanna and Mossad highlighted in their presentations. And it's perhaps interesting to reflect on the ingredients of this success. Now, of course, depending on your perspective, it's quite easy to identify one or two elements and overlook others. Of course, I must begin by the care and attention which was devoted to the establishment of the SCCA itself. That was pivotal. But think also of the policy drivers too. The new, not actually that new now, arbitration law and enforcement law back in 2012 and 2013, setting the scene. And as Ziad indicated in his comments, updated very recently so far as the arbitration law itself is concerned. And also with the continued impetus seen very recently in the procurement law, the GTPL, the Government Tender and Procurement Law of 2020, and the privatization law governing public-private partnerships of earlier this year. Again, pieces of legislation that Zayed Khoshaim touched on in his presentation. Beyond that, of course, law is fine, but it needs to be in the broader context, supported by the courts of the jurisdiction, supported during the arbitral process and after at the point of enforcement, as Henry was just speaking. One must add to the mix the specificity of the SCCA rules, paying close attention to considerations of Shari'a that Stuart was speaking about, recent rule amendments to Appendix 1 and the fee schedule, which was referred to in the video, and with ongoing work to make sure that the rules are fully responsive to changes in circumstance, whether that's prompted by COVID or otherwise. ADR Centre's success also reflects user choice and preference. It's not that many years ago that the kingdom was popularly regarded as off limits for arbitration, not least because of the perceived problems, some would have regarded it as impossibility, to enforce. How times have changed, as Henry emphasized, the ease with which you can move for an ex-parte application. The building blocks are, as he said, in place. What is needed is the track record. And of course, there is always a time lapse between putting a system in place and recognition and perception of what has been done. That will follow. Now, enforcement in Saudi Arabia is therefore well on the way to being reliable, and continuing with my road analogy, a well-metalled road in terms of dealing with issues of reciprocity, the emphasis or the clarity which has now been brought to the fact that the enforcement judge is acting procedurally only, the effect of submitting to the jurisdiction precluding a subsequent challenge, and also the sensible reminder that one should always educate one's tribunal so that proper form is followed. Another important aspect is understanding what different types of dispute resolution can do and can achieve. And here, while I'm not overlooking the merits of arbitration, I have mediation particularly in mind. Can mediation create a win-win outcome where litigation is, or arbitration is essentially zero sum, one winner, one loser? How is that legal alchemy to be achieved? And how is it also to be conveyed to actual and potential users? Here, of course, the outreach spearheaded by the Centre in relation to information and education programs has played a very important role, as the title of the webinar makes plain, making ADR work in the Kingdom of Saudi Arabia. It seems to me that all these ingredients have come together, enabling us to take stock of arbitration in the Kingdom, debunk some of the myths, and identify and analyze some of the trends. In terms of mediation, the panel has looked at what works, how mediation is becoming established, how it can be used to advantage. But there are, of course, also new avenues to be explored. One might be investor-state disputes, where in the last 4 to 5 years, there's been a detectable increase in certainly investor-state arbitrations, where Saudi Arabia has either been the home state of the claimant or in some instances, the respondent state. How many of those arbitrations might be susceptible effectively of mediation? That brings me on to the third and final thing that I want to do in these remarks. And it's really an extension of the point that I've just referred to. New vistas in dispute resolution are opening up. Indeed, to speak of avenues is perhaps too limited. New vistas, whether in the field of investor state or in artificial intelligence and digital disputes, or blockchain, or fintech, or perhaps most topical of all, in the field of environmental law. Saudi Arabia, as you know, launched the Saudi Green Initiative and the Middle East Green Initiative, both initiatives keying into the Vision 2030, which Zayed was referring to, albeit in a different context. Saudi Arabia started these initiatives, launched these initiatives in April of this year. The inaugural forum of both initiatives is now inked in the diary for late October 2021. Now, recently I was looking at the UN Environmental Programme and the first global report that it published into environmental rule of law, quite recently published in January 2019. In the course of the report, it spoke about, quote, promoting collaborative governance through inclusive procedures and mediation across a range of stakeholders. And the report, it's quite a long report, over 250 pages, went on at several points to emphasize the merits of ADR in the context of environmental law, but also environmental rule of law. Now is not the time to go into that in any greater detail, but I raise it as a further modest contribution to how ADR might continue to be innovatively applied both in the kingdom as part of the Saudi Green Initiative and within the wider region as part of the Middle East Green Initiative. That concludes what I have to say formally by way of my closing remarks. It's not, however, quite my last word. I have three short last words. First, to thank the panelists and moderators again. Second, to thank ArbDB and the SCCA for hosting this webinar. And third, to repeat what James has already said, namely that there is immediately after this a networking session, which I hope you will join. So I will now hand you back to the organizers. Do stay for the networking session. But for now, thank you all.
Thank you, Michael. And you'll all see what Michael said in the chat. The link has been posted there. It's also been emailed to all of you. And I want to echo what Michael said and invite you all there. Thanks again, Michael, for your excellent summation and analysis, as always. And also on behalf of Michael Cover, ArbDB Chambers, and Dr. Hamid Mirad, the CEO of the Saudi Center for Commercial Arbitration, and myself, sincere appreciation to Chris Alberti, Fatayar Taswiya, Masad Al-Kharb, SCCA, Ziad Hashem and Associates, Stuart Patterson, Herbert Smith Freehills, and Henry Quinlan, DLA Piper. Also, thanks to Martin Poulter of ArbDB, because he's worked to pull this event together as well, along with Mohammed Khalid, who runs the PR department, Chief of Marketing for SCCA, Musad's team with Ms. Nof, and also with Usman Nassim, because these people have done a great deal of work. So I'd like to invite you all to participate in this session. Please make sure you do click the link inside this box or copy it, or the one that was sent to you.